weekly social, everything Katy, Fulshear, Richmond, Texas. We have a couple lovely guests today here. We have Kerri Graham with the Graham Law Group. We also have Priscilla Pfaff with Luebeck.
Thank you, Richard.
Welcome. Tell us a little bit about yourself, Kerri.
Well, so I'm an attorney here in Katy. I've been here about 12 years. My practice's focus is on essentially things that affect the family. So family law like divorce and child modifications, child support, and then also a lot of estate planning and probate, a lot of litigations, a lot of courtroom work for me, lots of trips downtown to the courthouse.
Wow. Harris County?
Harris County, Fort Bend, and Waller, although I've gone to Montgomery for certain things, and we definitely do some of the smaller counties.
What brought you into being an attorney, I guess? What sparked you? Because most people don't go, I want to grow up and be an attorney.
Yeah.
So I was a teacher in Katy actually for the first 10 years of my adult life. And I ended up helping write some policy and do some things in the school district, which I found I really, really loved.
Okay.
And so research and writing, I was kind of a nerd, thought it was cool. And I one day just said, I'll take the test, see how I do, and go back.
Wow.
Wow.
Now, I met you, it's been quite some time.
Mm-hmm.
I want to say I met you with Christy, is that correct?
Yes.
Okay. So that's been many years ago.
Yeah, that's been a lot of time. I think it was probably about 10 years ago the first time we met.
Okay.
Wow.
Small world.
Small
Very
world.
small.
Small world. But, you know, I've known Kerri for years, and the reason I wanted her to come in is because she's the one I use to prepare my, will and power of attorneys and HIPAA and all of that. So I was like, she's got great value to share with everybody, and know that she's right here in Katy and is available to do that.
Speaking of that, what can the people out there that are watching this do to be proactive to mitigate some risk or problems that can come up in their life?
No, I think just starting by making sure you have an understanding of your assets. So I always ask clients to keep a list of what you own and how it's titled, and then keep track of your beneficiary designations and things like that.
We heard that last week too with the financial guy.
Yes.
He was very, very, telling us about that kind of stuff. So.
And just making sure you have your documents in place and then reviewing them as appropriate. So our legislature reviews our laws every 2 years, which brings definitive changes to things that are very important, like your powers of attorney. And so you want to make sure you're at least looking at them and asking the question, do I need to update this? And if you're a title company, I know you're aware, but if you ever try to act under a power of attorney, that real property description has to be in your power of attorney with the full legal description on it in order to do anything.
Right. It has to be specific to that property.
And a lot of folks don't have that. And so they get to the selling stage and realize they have a problem. And then we're looking to the court system to do a guardianship or some other really expensive court supervised proceeding. And so that little bit of proactive behavior of just touching base, making sure your things are current, if you bought or sold a home, if you've added a child, a spouse, any kind of life decision.
Or lost a spouse.
Or lost a spouse.
Yeah.
Right. And a common thing with that too is that when you have a married couple, a lot of times people hear from folks who work in other states or live in other states, and they think some of that property passes automatically just by virtue of being married, and it doesn't.
Not in Texas.
Not in Texas. And so failing to transfer that property and create a clean and insurable title can really cause you to later on lose a buyer, to lose money that you might need to retire. And so we see people pretty harmed by not, just asking some very good basic questions.
So being in Texas and that happens, and so tell them how it works. I mean, in Texas, if your spouse passes away, you get 50%, kids get 50%.
It can be that way. So essentially, we talk about the characterization of property first. Is something community or is it separate? Well, everything is presumed to be community property, right? That's the presumption here. But then we say, well, what does that mean? Well, I see a lot of young folks especially misunderstand the rules and they will purchase a property prior to getting married in one spouse's name. Maybe the other spouse is in school,
Right.
or they are not working, or they're new to their career, or they're having a baby. We just don't know.
Mhm.
And now you have a separate property home that
Personal
really
property.
was meant to be a community property home. And so we can inadvertently make something it's not supposed to be. And if we die without a will, now that's kind of bypassing our spouse, and they don't have an interest minus their, life estate. And so that can be
Oh,
really
wow.
problematic for folks.
Yeah. Wow. That's a lot. And we do see a lot of that because, one's out of school and they're already doing, and the other, they're going to get married, but they're still in school or whatever. And that can be, they're just not thinking about any of that.
Right. And new people, they're not, young adults, they're not thinking about end of life issues.
Mhm.
They're invincible still. They're going to live forever.
Yeah.
Right?
I'm still immortal.
Yeah,
Me
exactly.
too. I'm still immortal too.
Mhm.
We'll put our superhero cape
That's
on
right.
later.
Yes. But, okay, so we get asked a lot about, deed upon death and things like that. What do you see? How do you see that working? Does it work? Is it beneficial to do those things, or is it not?
Well, so far it's been okay. The legislature put the transfer on death deeds into our statutes, and then they took them out. And so
Oh.
that's been kind of interesting, and we're not really sure what's going to happen. I'm not a huge advocate. I think there's some other things we can do that are equally as good and maybe a little more tried and tested.
Okay.
Attorneys are certainly not cheap, so if someone's going to pay me to do work, I want to make sure we're doing something I feel confident is going to be, have some longevity behind it and
Okay.
really be successful. So I have a little bit of trepidation with the transfer on death deed. Not a lot, but I do them. But, they just give me a little bit of heartburn.
So you're saying it's changed, so if somebody has already done that, recorded it, and if they don't record it, it's not any good,
Right.
and a lot of people don't understand that document must be recorded
Well,
as soon
it's
as
like
you sign it.
divorces. How many times do we go to get under contract? It's been awarded to them, but nothing was perfected on the other side.
The deed wasn't done.
And then we got to work through all that
Mhm.
during this narrow window of being under contract.
Well, or we've got to record the entire divorce decree,
Yes.
which is a lot more costly, and you're putting all that information out on real property records now.
Yes.
Yep. It becomes, what's already public record, of course, in the divorce records, but no
Right.
one really looks there.
Right.
But deed searches are pretty common. And you can only do that if there's muniment of title language in the divorce decree that allows it. So we've seen divorce decrees where that language was missing, and now we have a person who's not cooperating. And so now we have to go back to the courthouse, and that is a really expensive mistake.
So when you're doing a divorce, do you automatically do the deeding it into the other person's, who's ever been awarded the property?
We definitely make our best efforts, but you can't control what people do. And I know it's a stretch to say not everybody's happy after their divorce, but sometimes unhappy folks are people who don't win at a trial, or their friends and family tell them their settlement agreement was bad.
Right.
They might not perform, and so you have to make sure that muniment of title language is in there so that if they don't perform, we have the ability to at least solve it with a filing fee, which is certainly better than lawyer's retainer to go to the courthouse and try to fix it.
Okay, that makes sense. What about, with probate and all of that fun stuff, and as we're getting older, are there things that you can share that people need to make sure are in place?
I think one of the most common questions I get from folks is I'll get phone calls and they'll say, hey, I'm the executor in this will, but no one's taking the will. And a lot of folks don't realize that a will is, I don't want to say it's a suggestion, but I will say it kind of is.
Yeah.
You're putting your wishes in writing, but until you actually go through the probate process, no one is authorized to do anything. So the presentation of a will without a court order doesn't get anything done. And so that can leave people very frustrated. And I think sometimes as attorneys, we know all of these legal things have to happen, but we might forget to say them to our
Yeah.
client. And then the family can be a little disgruntled or just confused why the will that they paid for wasn't enough. But a will is really a nomination. You're telling your executor what you want them to do, and you're telling us who you want to be appointed.
Right.
But when we take that will to the courthouse, probate means we're asking the court to do a couple of things. First, to say, yes, this is definitely this person's last will and testament, meaning it's the last one they wrote. Nothing has come up since then. And they empower and authorize that executor to stand in their shoes, and they get a letter of authority called letters testamentary, which allows them to stand in the shoes and act.
Right.
Really important if we want a clear title, if we're a real estate agent and we want to get a contract, we need to make sure that person doesn't just have a will, but they have those letters testamentary and they have the authority of the court behind them.
Right. Now, we do, you know, if it's not a big estate, we can do the affidavits bearship. Of course, we have to send it to our attorneys for them to review and make sure that, you know, that everything's covered.
To ensure title.
Right, to ensure title.
Yeah, there are definitely smaller things we can do when there's no other assets. And we can sometimes record wills too. There's lots of things I've seen done to solve different problems.
And we do record the will when we do an affidavit of heirship, so that it's following what the will is wanted, right? But so many times it's a little scary that, you know, somebody could have a child prior to and
Previous
somebody not
marriage
know,
children.
and
That's a common problem that I see.
Well, blended families are a real thing. They're a blessing, right?
Right.
We love that we have the second opportunity to create a home and build those relationships. But legally speaking, if you die without a will in Texas, Texas has a will for you. Those are called the laws of intestacy. And we don't always love how that works, because if you're married to someone and they die and y'all own a home and that person has a child from a previous relationship, that child inherits that half. You keep your life estate, you keep your house on a community property asset, but it's a little bit awkward to own a home with the other parent's child, right?
Yeah.
It's uncomfortable. And many times if that's a minor, now we're not just subject to the laws of intestacy, but a minor can't sell property, a minor can't inherit. And so now we're going to the courthouse to do multiple types of it. It's so expensive to have to do that.
Guardianship or receivership if the monies are needed? And I'm just asking.
It can be. So it can be a guardianship of the estate. Sometimes we have to look at the value. So whatever portion is going to the minor, sometimes we can do, there's an estates code provision that allows us to sell a minor's interest and then put the money right into the court registry. And then when they turn 18, they can go get it. Sometimes we have to do other things. If it's over, I think, $250,000, that's not an option. So it really depends on the number.
Okay, so the person, whichever one is still alive and living in the property, can keep it, can stay there.
Life estate.
Yes, so they can't, the kids can't make you sell it?
So if it's your homestead, you have homestead protection,
Okay.
right? But if you have other property and you have a life estate and say some of their separate property, maybe they have a bay house, or they have, you know, a house in another location, maybe they love Austin.
Yeah.
That's not quite the same, and any beneficiary can ask the court to partition and sell so that the beneficiaries can be purchased, get their money out of it.
Yeah.
On the personal property, not the homestead property, is that correct?
I'm not, well, it's not, it's still real property, but it's on property that is not the homestead.
Like a
Yeah,
secondary
so
home,
investment, whatever.
Rentals,
Yeah,
things
right.
like that.
Okay, all right. No, that was, I don't know why that's been a question in my head. You know, that, yes, you've got the homestead, but can the kids really make you get out of your property and, you know?
Your home's protected,
Okay,
right? You have a right to stay in your homestead.
okay.
That can also be frustrating. So imagine a scenario where husband and wife are married and wife or husband has children from a previous relationship, and maybe that's the asset they're inheriting, but maybe now the parents are only 60 years old and the other person can keep that property for 10, 20, 30 years. You might not see that inheritance for a really long time, and yet as the remainder beneficiary, you're going to have to pay, you know, taxes and insurance. There are things that you're still maybe monetarily obligated to, and so it gets really tricky.
Oh, never thought about that.
I see a lot of properties that they go into dilapidation and stuff, and then by the time the kids get to it, I mean, it's a challenge.
It's
I mean,
diminished, yes.
it's a Yeah, it's a big challenge.
Wow.
Because it would cost more to renovate than what the property's gonna bring on the
Right.
retail market.
Right. Wow.
And it's sad to think that would have been solved with just the purchase of a will, right? Just a
Yeah.
little bit, just a little bit
Yeah.
of
Just a
work
little
on the
bit.
front side
Yeah,
would have done
just
a
a
lot of
little
difference.
bit.
But
Yeah.
people don't know.
No.
Look at how many famous people die without wills. Prince.
Yeah.
Or judges or lawyers, like what is it, the cobbler's children have
Yes,
their shoes,
yes,
right?
Yes.
yes.
Shoemaker's kids go
Yes.
barefoot, yeah.
They go barefoot.
We're all
Yeah.
immortal.
Obviously.
Oh, wow. Wow.
Richard, I have a question here. Someone said, how about dual tenants with rights of survivorship?
That's a really good question. So the question was about dual tenancy with rights of survivorship, which is a thing in most states. I wouldn't say you can't do that here, but that is not our go-to practice.
Okay.
There are states where they automatically, with spouses, do a joint tenancy with a right of survivorship. So if one spouse dies, the other one gets the house. That is not Texas go-to. You probably don't see that on deeds. It's not something we typically do here.
No.
Okay.
No.
Yep, we're gonna get some questions here.
Okay,
Yeah.
cool.
Thank you. That was awesome.
Yeah, yeah. What about, okay, you've got, your parent and they are getting older. What are some things that you would suggest, like if it was your own parent, what are some of the things that you could suggest that they make sure are in place to kind of protect them?
Thinking like POA and DNRs, which I know I'm speaking in our jargon, so we'll probably want to explain that a little bit.
Right,
out there
and
to the general
HIPAA
public.
and all of those things, but what about their properties?
So I think if you have some basic documents, right, your will, a durable power of attorney for your finances, a medical power of attorney to appoint a decision maker, a HIPAA release, which is sort of a global, these are people who can have my health insurance information,
Yeah.
and then a directive, which is kind of like a global DNR for folks who are familiar. A directive is you giving your family and your physicians your wishes in the event you have a terminal or an irreversible condition. You can even write in some special things. Folks have religious rules where they can't get blood transfusions or maybe even
really?
accept medical treatment. And there's a way you can write that down so that your decision makers know. The biggest mistake I see that folks make with those documents is that they name co-agents. And so it's kind of important to know that like your financial power of attorney doesn't have to be accepted anywhere. So you can have a valid document, but if there's liability to a bank or a financial institution, they're not going to take it. And one of their biggest liabilities is co-agents. And it sounds great to us as parents, right? I trust my kids together, they're going to work together.
Mm-hmm.
But a bank doesn't want the liability of figuring out who to listen to if they disagree.
Right.
And so I always encourage
So they just
Chaos.
want one person
one
on
person
there.
at a time. And I always encourage parents to think of it as a tiebreaker. In the event your children have a disagreement,
Mhm.
who is going to be the person we direct us to listen to? And for your financial power of attorney, we want that to be someone who's good with money. If you have a child who's not stewarding their own wealth, please don't trust them with yours.
Yeah.
Right?
Yeah.
And for medical, we want to think about which child has the emotional bandwidth that if they had to pull the plug, God forbid,
Right.
they could still sleep the next day knowing they honored your wishes
Mhm.
and they wouldn't be traumatically harmed. Or think about the child who would follow your wishes even if they disagreed. Right? That should be the tiebreaker. And if you don't
Character.
have that,
That's huge.
it's scary.
Yes.
Yeah,
Yeah.
that's huge. Well, that's like when you and I sat down and put all mine together, I made the executor also the one that has to make the decision on, my medical and all that stuff, so that the girls didn't have to do that. And then we put in there also, they couldn't get the money until they were
Certain
35.
age, which that's smart.
Yeah, and then it could be invested in all of that, until that time. Yes, could they pull money out if they needed it or whatever? Yes, that's available. But they don't get the whole thing until then.
Can I rewind a question while we were talking about the banks?
Yes.
Because I see another problem out there, a lot of times is they'll put an authorized signer on a checking account when they hit a certain age.
Yes, and most of the time they're not on there as a signer, they're on as an owner. Because most of the banks don't know how to do a signer.
Right.
And so if you have an account with $100,000 in it and you put your child on there, this now passes outside your will and it goes to that child as
And
an
they can
owner.
wipe
Because it's
all
almost
that
a
money out.
it's a beneficiary, basically.
It's a joint tenant, that is
Yeah.
a joint tenancy situation. And by operation of contract, the other owner receives those funds. And you can
Wow.
inadvertently change your estate plan by doing that. And for a child with maybe lesser than morals, they're going to take that money and run.
Yep.
And for a child with good morals, now they're trying to redistribute, but it's a gift. So now it's reportable potentially. Now it's eating
It's
up
taxable
income, not necessarily
Okay.
taxable, but it's reportable, and it eats up their ability to lifetime gift to their own kids. So we can create these issues on accident that are really a big deal.
This is really good stuff,
Yeah.
Kerri.
Yeah.
Or really bad stuff.
Yeah, well, yeah.
It's
So,
depending on how you look at it.
so really, what you're saying
true.
is somebody should have your power of attorney to be able to access your stuff and not put it on the account?
Yeah, so if you bring in a power of attorney to a bank,
Mhm.
they'll add you to an account as an agent under that power of attorney. And so now you're not an owner, you're just operating in your loved one's shoes as an agent for them. And so now you can be on the account with your agency and not as an owner, and banks do know how to do that. That is something they can do.
If you bring in the power of attorney that
Correct.
is directing that.
Correct.
And so that should be done prior
It needs to
to,
be crafted by somebody that knows what they're doing.
because, well, and also a power of attorney is only good if you're alive.
This is true. If
True.
a
It's not
power of
good
attorney
if
dies with you.
you're,
Well,
you passed.
and you have to be coherent.
Yes, yes. Or we have to go through the doctor and the doctor has to confirm that they are.
And that's hard.
Yeah.
It is
Yeah.
hard to get doctors to write letters that say you're incapacitated
Mhm.
because it results in lawsuits, and doctors don't want that liability. They don't want to go to court
Mhm.
and testify, and so it's hard to get doctors to do this.
Yeah,
Proactive.
yeah,
Mhm.
yeah.
We were talking about properties earlier as far as deeding and all of that. What about trust? Because it's not just the property and the clouds on title, it's the tax implications.
Mhm.
So what are your thoughts on
On a
family trust? Or, and I could be jumping into rabbit holes, but I'm just...
No, it's a great question, one I get all the time, and I think in a world where we have these amazing experts out there like Dave Ramsey and Susie Orman, they really have some great stuff. And the issue with Texas is we're a very property heavy state, and so we really do take real property rights just very seriously. And so the other thing that affects us in Texas is we have something called independent administration of probate. So we're not a state where you have to avoid the courthouse. Probate's relatively inexpensive. It's pretty quick here. But if you go to some other states, it can take years, and you have to ask the court for permission to do everything. So your attorney costs a lot of money. And so trusts in a state like that are just needed to avoid the probate process.
Okay.
But in Texas, a trust is expensive to make, and it's only as good as the paper it's written on, which means if you lose it and we don't have it to reference 20 years after you wrote it, we're now going to the courthouse and looking to the trust code to figure out what it could have, would have, maybe should have said, right? So it can be expensive litigation. So I do like them for certain things. If you've got a disabled child, it's irreplaceable. You have to have a special needs trust for that kiddo. If you've got out-of-state property, we can help you avoid out-of-state taxes, death taxes, local taxes, by having a Texas trust and getting the benefit of Texas law. If you've got oil and gas interest, it can be a great way to manage those and keep them much more streamlined. And if you want to control your kids after you die, a trust is a great way to go. But
Helicopter
Oh,
moms.
wow.
I mean, you know,
Wow.
some people do that.
Yeah.
And we certainly see it, and it can really be a problem solver. Like, I've seen great use of a family trust when you have a property that you use as a vacation home, and maybe your kids get married and the spouses don't get along, but you want your kids to have an excuse to see each other. So we've done some pretty cool creative stuff,
Oh.
but you really need to have a reason to do it.
Interesting. Okay, because everybody says, oh, you need to get a trust, you need to get a trust, you know, and have everything set up through that. But I didn't really understand why.
Well, I think it's different for every person. They're not a go-to planning tool for every person. It really depends on the circumstances, and that's where I think, you know, those of us who I think litigate estates,
Mhm.
we're always like, estate planning's not a form practice. It's not form.
Yeah.
This is why, right?
Yeah.
We don't want to give you a form.
And that was the, major thing with you is you do go and do those and you litigate them and you're in probate and doing all that. So you know the proper way to make things work.
I mean, no attorney's going to know all the things every time.
Right.
Certainly we're not perfect.
But you've learned it. What doesn't work?
We learn, and I think it matters because, I practice in these counties, and if my wills get in front of these judges.
Mhm.
So it's my reputation that sits there.
Yeah.
And then, the more you litigate, the more you refine the way you draft. My powers of attorney look substantially different than someone else's because of experiences I've had and lessons I've learned.
Right. Wow.
Mitigating risk.
Yeah.
Always.
Yeah.
Yes.
Yeah. And the other thing that, we come across sometimes is somebody's getting divorced. The divorce is not final. And one of them wants to go ahead and purchase a property.
Which is community property.
Yeah.
Still.
Yeah.
Because you're still married.
Yeah.
And we can do things, we can have agreements, if everyone's getting along enough, if they can be motivated to get along, we can
So
have
there
agreements
is
about it.
something that can be drawn up to where that can stay as their separate property.
We can agree that we're going to affirm it in the final decree of divorce.
Okay. That's good to know because we do run across that sometimes. Because
Well, when you're a
You're-
homeowner, nobody wants to go back to renting.
Right.
Because you're burning money. It's 100%.
Yeah, but the other spouse is keeping this property, but you don't want, you want a property to take the kids to or whatever, and they're like, what do I do? And I'm like, don't until you're done.
Right. Or be proactive and get things in writing. An interesting, awkward scenario sometimes we see is, a long pending divorce, someone will go buy property with another person, then they marry that person, and 10, 15 years later they want to sell, and now they're having to come back and include that first spouse, because they purchased it
seen
before
that.
the divorce was final. And that's just uncomfortable. Nobody wants that situation.
You want to
That's
close them
not fun.
separately.
Yeah.
Yes.
Okay, so give us a scenario of worst case situation, not that you prepared documents, but
Right.
that you helped somebody get through. Divorce, probate.
Oh, you're just asking for a bad situation.
Yeah, just a story.
The craziest story.
Mm-hmm.
Did-
There's numerous ones, and to choose from that
I'm
is
just a little hesitant
Yeah.
to tell client stories.
yeah, but just generic kind of.
I think places where it gets tricky is when people have multiple relationships or babies out of wedlock. That gets very uncomfortable. Maybe not at the same time, even just consequently you have these children who don't know each other, and we find out down the road in a probate, or people who don't clean up. I've seen several things where people do not clean up their marriages. Maybe they file for divorce, but they don't finalize it, and they think
I've
they're
seen it at
divorced.
the closing table.
Yes.
They admitted that they were married when they saw the closing, when they said, "Are you married?" Well,
Yeah.
I filed, but
It's
got
not
another-
final.
but they weren't divorced.
Yeah.
I've got another question here. What is the difference between per capita and per stripes or stirps?
Sturbies.
Stirps, yeah.
I have no idea what that just said.
I don't
So that's asking about the laws of intestate and or some terminology we use in a will. So when we talk about things per stirpies, we're going to follow your bloodline. So let's say I have 3 kids. When I die, my 3 kids inherit equally, but it may be me and this child die at the same time. This share, and under a per stirpies designation, would go to their descendant.
Right.
Per capita means we're not going to follow the bloodline necessarily. We're going to look at each group as a class. So maybe your grandchildren are a class, or nieces and nephews are a class. And so we always talk about how do we want to distribute if there's a death, because it's really important to make sure we're doing what we want it to do. Most people follow the bloodline. They want to make sure that they're not inadvertently removing inheritance from someone who would have inherited if their parents survived.
Right.
And so that's more common, but sometimes if you don't have kids and we're looking at nieces and nephews, per capita becomes a little bit more.
Okay, so say it one more time, just, per capita does this and the.
So per capita looks at us as a group. So you have maybe the person who wrote the will, and then their next line of family if they don't have children.
Whichever they specify.
Right, so we're going to talk
So
about.
even if they have children, can they still specify it to go to the grandchildren?
You absolutely can. You can write out your spouse, you can write out your kids, there is no obligation. What we don't do though, y'all, is leave people $1, because then they're entitled to notice. So make sure if you leave somebody something,
And
you
that's
make
all-
it worth their while to not fight.
But that's always been the thing. You have to at least leave them $1 so that you've covered it.
No, that is not accurate. That's a way to make
That's an
sure
old
they
wives' tale?
Uh-huh.
find out about the will. So everybody in the will is entitled to notice, but if you're not in the will, no notice. So if you're cut out, I can take that will to the courthouse and probate it and get things distributed and close it out, and you'll never know
Without a fight.
without a fight. But the minute I leave you $1
You're notified.
or a book collection
Yeah.
or china or your stuffed animals when you were a child, you're entitled to notice.
Wow. Wow.
Interesting.
Yeah.
So it just begs
Because
the
it's
question.
always been that $1. Give them $1 so they can't come back and mess with it.
Accepted.
You're,
Right.
you're creating your own problem.
Yeah, you're stirring your
Okay,
own pot.
so that is under, well, no, that's not necessarily under. But if you're going to the grandchildren, then you're specifying in the will what? Like you're skipping the children and going to the grandchildren.
Well, you just say that. So you would identify your class of, I have this many grandchildren, these are their names, and then you inherit them just like you would of your kids.
Okay, and then the other word
You
was?
can pick and choose
Yeah.
the people that you want to inherit.
Right, but then
It's
the
when
other
you
word
don't
from our,
have the will
The-
is
the-
when it gets messy.
Per capita is like when you designate, say, all my nieces and nephews, right, who are alive. We're not
Oh,
going,
okay.
if they die, they don't, right, it's just all of them. But we're still
Oh.
identifying them, we're just treating them as a class of people, not each person individually.
Not blood. It's not
It
going
still
down.
might, it still might be
It-
your blood
yeah.
relatives, doesn't have to be.
But it's
it
not
could be.
going down the bloodline like you were talking about. Like if if a child passes, then it would automatically go to the grandchildren.
Maybe an easier way to say it is with the per stirpes designation, each person is treated individually based on their alive or dead status. As per capita, we don't look at each person, we look at who's alive in this class,
Okay.
and we stop there.
Got it.
That's it.
Simplify.
That's
Yeah,
it.
sorry, that
Thank
was
you.
a little
That's okay.
confusing.
No, thank you, because I just knew, I just wanted to make
That's
sure
why they need
that
to
that's
hire.
where they wanted, what they
Right.
wanted to know, and we kind of put it in layman's terms, because, that's why we need you, because you are the specialist, you know how all that works. That's why we need a realtor. They know to get you from contract to closing, from listing to closing. Title company, they need us because we know how to work through it.
Well, and we all offer a different level of protection,
Mhm.
right? When we rely on an expert, we get protection from that.
Mhm.
And that's important, because once you're in a lawsuit, that doesn't just go away, even if you're right,
Mm-mm.
even
You're
if you're
gonna
wrongly
take the
sued.
line.
You're gonna take the ride and you're gonna spend the money. And
Mm-hmm.
if you can do things along the way to make it harder for someone else to find that liability towards you, you wanna do it.
It's a transfer of risk.
Mm-hmm.
That's, a lot of people think that they're saving money, but they're stepping over dollars trying to protect pennies. I see that so often.
Yeah, you're right. The one other question I have is, let's say that, how do I put it together? Somebody's passed, they never probated, the next spouse has passed. Can the last one be probated for basically both?
So if I understand you
So it was like a
correctly,
mom and
you have
dad.
a husband and wife,
Mhm.
and they both have wills.
Mhm. But the first one wasn't probated, the
Right.
wife passed. So now the husband is still alive, and then he passes, but never probated the wife.
So you're still gonna have to do something to probate the first will, because each of the spouses has to pass their half of the estate,
Okay.
right? And remember that community property doesn't depend on titling. So if a husband and wife are married and husband has a $500,000 IRA in his name and wife has, CDs in her name,
Mhm.
those are all still community property and the ownership is still there. So even though the husband's name is on the IRA, wife still has a 50% interest. Same for those CDs for husband's interest. And while those may have beneficiary designations and pass outside of a will, the home is not going to. And each of their halves has to be accounted for.
Okay, so it has to be the full.
Yeah, it doesn't
Both of
mean we're
them.
doing a full probate. We might do amendment of title, which is a smaller proceeding that just
Right.
settles title, maybe affidavits of heirship, but we are doing something to clear that ownership interest.
To address it.
Mhm.
Yeah.
I want to say thank you, everybody, for tuning in this week. Wonderful guest. If they want to reach out,
Alzheimer's. Alzheimer's.
oh yes, please donate, subscribe for donate, and join our team for the Alzheimer's Walk, which is going to be the 28th of September. We will be at La Centera. We will be doing a live podcast there with the Alzheimer's Association.
Yes.
They called me and asked me to please come down because they got such a great benefit for doing the podcast with us. So
That is awesome. I love that.
That's great.
Mm-hmm.
But we want to give a shout out to Kerri Graham at the Graham Law Group. What's the best way for them to connect with you?
So my website is easy to find me there. It's
Okay.
westhoustonlaw.com, and the office number is 281-972-7192.
Perfect.
Thank y'all for having me.
Thank you.
So get your affairs in order, figure out that, yes, you do need a will, you are not immortal, and give this young lady a call, and
Yes.
she's going to help you out.
Right.
Thank y'all so much.
All right.
Thank you.
Thanks. See y'all next week.
Bye, guys.